awesome quality.
And it's interesting because her dad is on Colorado Court of Appeals. Which is kind of an interesting.
It is, yeah.
Family dynamic.
I googled amicus today.
The pronunciation, or?
Just get a second opinion on it.
Yes.
And you were number one. Google search.
In what sense?
Great articles.
Oh.
For Fordham
Really?
and also the.
Stanford.
Yeah.
Oh, animus, you mean? Sorry.
Animus.
Okay. Yeah. That's great. Now I just carved out my little niche.
Yeah. You were definitely the authority on the topic.
Isn't that great? That is so fun. And it all came out of this seminar that I've been teaching. I taught at DU for 3 years and then at UCI for 1 year. Yeah, it was really very fortuitous.
Professor Pollvogt, I need to bring it, but the copy you gave me isn't your article. It's Professor Kennan's. Is that? Did you guys?
I gave you two. One is
Forgetting Rowe?
No, the one that in your left hand.
What's one?
Can I say it real quick?
What?
Unless I yeah, no, it's Professor Kennan's article. And I kept looking at it. It's so funny that it's another professor from DU. But the front says your name and says unconstitutional animus. And then the actual article
Is it the same as?
No.
Yours is unique.
This is
Indeed,
well. And I was
effective.
going to bring it and then I locked myself out of my apartment. But I'll bring it on Wednesday. It's so weird. And it's weird that it's a professor that we know.
So
I was like, wait.
No, it's about domestic violence, which is Professor Kennan's area of expertise. But yeah, they just must have printed the wrong
That's so
article in the wrong
frightening.
cover. So
yeah. Okay. So I have a number
okay,
in
great.
my
Well, we
office, so
can
you can
trade.
come up.
You can keep that one, you and Professor Kennan.
Weird.
Yeah, it's really
Oh
fun.
my god.
I know, before sending them out.
Well, and I just, they sent me this. I mean, it's nice to have those bound copies, but they sent me this huge box of them, which is kind of a leftover practice from whatever. I really don't know what to do with them, except maybe some kind of cat litter substitute or something. Okay, well, I don't want to wait too much longer. Hopefully, Allison will be able to join us. The preview. 311, we're going to the Supreme Court. Justice Marquez has agreed to meet with us. She's going to talk about, the stuff you guys want to hear about in terms of expectations of judicial law clerks, but also give us a tour of the new building. So it's just really fantastic that she's available to do that. So just make sure you put it on your calendar, and we'll obviously talk about it beforehand, but the syllabus, has this meeting for class on the 11th, and then having a speaker on the 13th, so just make sure you recognize that that's changed. Wednesday, our next class meeting is going to be a writing workshop, and we're going to have a few of these in the semester, and the idea is that it's really a work session, but where we can talk and trade ideas, and I can talk to you guys and give you feedback. But what you're going to do at that point is start drafting a summary of the district court and the Ninth Circuit decision. So that's something that is very typical to include, obviously, in a judicial opinion as a summary of the lower court decisions. And so we're going to work on that process. And so you're already building, the components of your judicial opinion that you're drafting.
So should we have that prepared for Wednesday, or we'll work on that on
We'll work on it in class on Wednesday, yeah. So whenever we're writing workshop, it's really, it's not about preparing it ahead of time, but working in the workshop together. And then Monday, the briefs should be all filed. And so, and obviously excluding the reply brief. I think it's just the opening and the answer brief. But we're going to go ahead and bring those to class and look at those together and sort of figure out, again, how to talk about the parties' arguments. Do you want to talk about the entirety of the parties' arguments, and what level of detail do you want to minimize that? And then Wednesday will be, again, having a writing workshop where you're going to be outlining your opinion, and that's going to be really the sort of decision point about what path you want to take through the equal protection analysis. The nice thing is, with the district court decision here, you have a factual record, so to speak, really, that supports a lot of different approaches to the marriage equality problem presented in the Perry case, and you don't have to confine yourself to what the Ninth Circuit did or what have you, okay? So that gives you a lot of options.
Professor Pollvogt, I didn't ask this question very artfully last week, but with our opinion, we aren't going to do any arguments that aren't in those two briefs. I was trying to ask generally kind of about how we limit ourselves with what's presented in the briefs themselves.
So, I mean, this kind of goes back to the question of, the court exercising affirmative, agency on its own behalf or whatever, sua sponte addressing issues. If you affirm, you can, right? If you affirm the Ninth Circuit, you can talk about issues that maybe aren't in the briefs. But you can't, as the court, you can't sua sponte raise an issue that hasn't been briefed and just make that the decision point.
If you're reversing. Or
if you're reversing.
Tell me the distinction you're making between.
So if you affirm, you can affirm on any basis supported by the record. The issue does not need to have been preserved by the parties or argued or what have you, right? It does have to be supported by the record. But if you reverse, it has to be, it's limited to the arguments raised by the parties, or else you have to then ask for supplemental briefing or remand it for further proceedings.
Right.
So let's look at that, let's revisit that question in light of what is argued in the briefs and what you're kind of thinking. Do you have anything in particular in mind, or?
No, I think the suspect classification thing is kind of fun in a broader sense.
It is, and you really have some stuff to work with there in terms of what the trial court did. Well, if somebody wants to go to SCOTUS blog and pull up the appellant's brief, we can see what's in their table of contents. The appellee's brief is due on the 22nd, so that won't be in yet, but then we can start thinking about that. So Allison, obviously, we're on the email, but just that we are going to the court.
Great.
On March 11th, which
Great.
should be great. Yeah, I think that'll be really interesting, a lot of fun. So it's different than the syllabus, so just make sure it's in your calendar and
Okay,
that kind of stuff.
Sorry, I hit some traffic on the way here.
Oh, that's all right. And then on Wednesday, we're going to be working together, right?
Okay.
So there's no reading, no additional reading or anything like that for Wednesday. Okay, so I feel like that's still kind of an incomplete answer, but I think it's better if we look at it in context. Does somebody, Will, do you have the?
Getting there.
I think that's the
Are you guys seeing the docket with all the filings and stuff like that? So there's a case page on SCOTUS blog for Hollingsworth versus Perry, and they'll list the filings in the case.
That makes sense, though. And if I did want to explore suspect class and affirm, then that would be open underneath.
I'm trying to think of.
Sorry.
I just want to be like, you need some help.
I feel like I'm like in a cartoon right now. Like everything just keeps going wrong. Okay.
You're all good. You're all good.
I think I'm good.
Well, what are the bases on which the Supreme Court could reverse?
Well, he didn't leave them a whole lot, but
Well, so, okay, and I actually haven't thought this all the way through. So this is, again, you guys, I hope you don't mind. Sometimes I go a little off track. Not off track, but, address things a little out of order. But if the court were to reverse, so what the Ninth Circuit did, and we're obviously going to talk about this today, it said, we're going to look at rational basis review.
Appellant's brief.
And
the appellants.
Yeah, so
basically two things. There's no rational basis, and there's animus as the Ninth Circuit defines it, right? So the Supreme Court could say, well, we disagree. Yes, there is a rational basis, right? And no animus. But what does the court have to do? This is insufficient. It's not addressing all the parties' arguments, right? So the court can say, well, it survives rational basis review, but the court would have to affirmatively establish that rational basis review is the proper standard. So it would also have to reject, the sex discrimination, sexual orientation equals a suspect or quasi-suspect class, and the fundamental right argument. Right? Because a court can go straight to rational basis review and not explore the arguments for heightened scrutiny if it's going to fail under rational basis review. Otherwise, the court has to give them a chance to argue for heightened scrutiny. So again, in terms of, are there issues outside of what has been briefed and raised by the parties? Nothing's coming to mind right now, but that might, be more clear once we look at the briefs and start to outline the arguments. Okay. What did you guys find in terms of did you find the table of contents?
Yeah, I think I have it here.
What you got?
All right, so their argument first starts with standing, that they do have it.
Right.
Then second is Prop 8's validity does not turn on the timing of its adoption.
Okay.
So I'm saying that it's not unconstitutional under Romer.
Yeah, let's try to frame that as, let's say, yes, there's a rational basis. The sort of fact of taking away rights does not deprive it. Doesn't change the level of scrutiny, does not deprive Prop 8 of a rational basis, and does not equal animus. That's probably really what the focus is there. Right, you guys know what they mean about the timing argument? Mm-hmm. The Ninth Circuit, as we'll talk about today, made a big deal out of the fact that, the rights were granted, the rights were taken away. What else?
And then
I think it's a poor argument heading, I'll say, because I think it's not clear what the legal issue is.
Yeah.
Okay.
Then the third is focusing on equal protection.
Can you read the heading?
The Equal Protection Clause does not forbid California from defining marriage as the union of a man and a woman.
Again, that's really poorly stated because you don't even know what level of scrutiny they're talking about there, right? That's sort of a broad assertion of that's permissible under the Equal Protection Clause.
Yeah, I don't think they really address the level of scrutiny in any of these headings, but
Okay.
then they have kind of 4 subtopics.
Okay.
First, looking at Prop 8's actually advances society's vital interest in responsible procreation and childbearing.
Okay. So I mean, again, the language kind of strays, but okay.
And it has a couple of subheadings of those.
Yeah.
And that's where it addresses under that it's not irrational.
Okay. So they're kind of mushing, we'll have to look at it more closely, but they're kind of, they need to address the whole spectrum of possible standards, right? So they want to argue not only that it satisfies rational basis review, which was the Ninth Circuit standard, but if you apply strict scrutiny, we got that too. We're covered, okay?
Next, they have Prop 8 serves California's interest in proceeding with caution before fundamentally redefining a bedrock social institution.
Okay.
Proposition 8 restores democratic authority over an issue of vital importance to the people of California.
Which is kind of a non-issue because obviously supporting democracy is a compelling state interest, but you cannot abrogate the Equal Protection Clause through popular vote, basically.
And then their last is just simply saying that Prop 8 does not dishonor gays and lesbians.
Okay, and so this is kind of Brown versus Board of Education badge of inferiority argument. Okay.
So,
And also, I would say that's tied to animus, but
so those are their 4 now?
Yeah, they've changed their arguments at every level.
Okay.
Okay. Which they can do because there only has to be some conceivable support for the law under rational basis review.
Yeah.
Is the democracy, that's not trying to soak up sort of the religious freedom thing?
I think it is. I don't know if that's, because that obviously was an explicit basis at the Ninth Circuit, and having not read the brief, but I assume that that could actually be incorporated in there because the idea is leave it to people to figure out what they're comfortable with and when. Okay, it's kind of a freedom of association or freedom of religion.
What is the caution one?
That we have an interest in proceeding slowly with social change. And it's, I mean.
So the first two that you've had, I mean, we've read
Yeah.
kind of as they are.
Yeah.
Do you think the democracy one is also like a kind of a federalism argument that, I mean, you have a fundamental right to marriage, but the states give you all the state benefits, so they should determine what marriage is? I just don't like.
I don't know that they've phrased it that way. I mean, you know, if you think back to Loving versus Virginia, you know, United States, or rather the state of Virginia said, this is a matter of state law, basically. You know, it's within the state's police powers to decide what marriage means. And the court was like, that's fine, caveat is always the 14th Amendment. Mm-hmm. So, I don't think it's I think it's more, you know, democracy versus judicial intervention. I don't think it's properly characterized as a federalism argument necessarily, but we'll see what's in there. Mm-hmm. Okay. All right, so let's go back to reviewing the basic moves in the district court opinion. And so what I want you guys to do is just take a second and try to describe the main points of reasoning in the district court decision in four points. Okay, this is just an exercise to help you kind of conceptualize the whole of the decision.
What was your directive there? Sorry, I was looking at this blog.
It's good first. Summarize, but again, in bullet points, the four major aspects of the steps in reasoning by the district court in a Perry case. What I'm writing has nothing to do with what you're doing. Anybody come up with anything good? 4-point summary of Harry versus Schwarzenegger? Go ahead.
I'm not sure.
Here. Yes?
What? I don't think this is.
No more equivocating.
Okay.
No more caveats,
Okay.
disclaimers.
Fine.
You're doing the district court?
Yeah. I think that's more the 10,000 foot than maybe what you're looking for with.
But is this the district court or the Ninth Circuit?
The district court, I mean, the Ninth Circuit,
Yeah.
they did one and then split, then went straight to 4.
Yeah. No, that's cool. That's cool. I did ask you guys to do the district court, so that's why I asked you if it was the district court decision. But the Ninth Circuit decision, I think that's pretty accurate too.
But he skipped 2 and 3 in the Ninth Circuit.
The Ninth Circuit. No, the Ninth Circuit did not address 2 and 3. That's right. So does this represent? Is anybody else following me?
You're asking for district court, and that's more of like the process on the Ninth Circuit.
I mean, so the Ninth Circuit addressed standing, and it really fixated on Romer, right? But it didn't take step 2 and 3. What did the district court do? It didn't talk about standing,
No.
right?
The finding of fact as adjudicator facts as opposed to legislative facts.
Are we still at the district court level? Okay, I feel like I'm
It's more of a
Well,
Ninth Circuit.
Yeah.
They talked about the distinction, but they're just their comprehensive findings of fact.
Well, exactly. Okay, so that's one of the 4 points that I had in terms of, big steps by the district court. 1, comprehensive findings of fact. Right, and the point being that those are available to you all in drafting your Supreme Court opinion, okay, all of those. Step 2, the due process fundamental right prong. What did the district court conclude there?
But it doesn't really matter.
Fundamental right to choice of partner.
So, the ultimate conclusion, yes, Prop 8 burdens a fundamental right. And the idea being that it's because it burdens sort of core/transcendent values of the institution of marriage, right? And so core transcendent values include, choice, setting up your household, etc. Non-core transcendent includes what?
Gender roles.
Yeah, exactly. Okay, gender roles, and in particular gender differentiation, right? So if this is not central to our understanding of marriage as a fundamental right, the fact that this is not part of what plaintiffs are claiming doesn't destroy their claim to traditional marriage, right, as a fundamental right that they're being deprived of. And the other piece of step 2, domestic partnership was insufficient to eliminate the burden on the fundamental right. Okay, so you have proponents, or at this stage, still the state arguing that, okay, even if marriage is a fundamental right, it's not really being taken away here because you have everything else. And, this is where the court talks about dignity and social meaning, right? Okay. Then step 3 was this dicta that sexual orientation equals assessed by class or classification. And then step 4 was to say, but the question we're going to answer is, does the law survive rational basis review? So this is exactly the right level. This is the level that I'm talking about.
Number 1 is different.
Yes. And I think the Ninth Circuit focused more on Romer than the district court did. Okay, so what we want to do now is go quickly through the district court's treatment of the purported legitimate state interests. And these are the state interests. Defining marriage as a man and a woman. What's the response to that? What type of argument is that?
What's the response from the opponents?
Well, from the court, how does the court treat that argument? But also when you're talking about sort of saying marriage is between a man and a woman because marriage is defined as being between a man and a woman.
Your argument is circular. You're saying,
Okay.
I mean, your premise is the same as your conclusion.
Right.
Same as your evidence.
What's another name for this?
Tautology.
Yes. And interesting, the first year that I taught this course, this was one of the most compelling arguments for students in the class. And I think it's just a lot has changed around this discourse since then. Okay. Caution. Caution in proceeding with social change. How did the court deal with this argument? Do you remember? Didn't they say that?
I'm confused between the two now.
Yes.
Okay.
Because in the Ninth Circuit, didn't he say almost...
Oh, between the Ninth Circuit and the district. I know.
Yeah,
It's
yeah.
a little, yeah. Mm-hmm. Go ahead.
Ninth Circuit, I thought his argument was more like, this is a dramatic change from what it was, so it doesn't make any sense to say that we need a proceeding. His whole rights were given and then taken away, so you're actually creating
It's a different
change.
argument than the district court made. That's right. That's right. So the district court said, the district court's kind of looking at a different point in time, right? And saying, well, if you're so worried about what granting the right to marriage did, it actually didn't do that much. Taking away, which is what the Ninth Circuit focused on, is a different matter. And what I want to point out, coming back to this sort of basic schematic of the levels of scrutiny, the more I think about equal protection law, the more I think this is really important. That under either form of heightened scrutiny, strict scrutiny or intermediate scrutiny, heightened just means more than rational basis review, the burden is on the defendant, which is the government, to show there's a sufficient state interest and that the law, the classification at issue, is sufficiently tailored to serve that interest, right? And then under rational basis review, the burden shifts to the plaintiff. To show the absence of these two things. The absence of any conceivable legitimate state interest, and that the classification is in no way rationally related to that. Okay? And it's, I think, almost more than this being a very low substantive standard, it's the fact of the burden being on the plaintiff to prove a negative that makes rational basis review so hard to prevail under. And what I think is interesting here, and so I didn't make a big point of this in the article, but in some of these winning rational basis cases, the court appears to be shifting the burden onto the government. Right? So, basically you have traditional rational basis review, and then you have this oddball set of cases. And it's kind of like, well, what's going on in those cases, right? One of the things I think is going on is the court is actually shifting the burden to the government, despite the fact that it's supposed to be on the plaintiff under rational basis review.
That's like
yeah.
what some scholars call rational basis of the bite.
Yeah, so Gerald Gunther was the one who originally coined that phrase, and it was, I think, 1973, when the court all of a sudden had this sort of spate of winning rational basis review cases. And Gunther predicted that that would become the new standard. It didn't. This seemed to have been an aberration. But that's exactly right. I think Professor Chen, the way he teaches it, is that there are 4 levels of scrutiny. The court, it's important to note, the court has never acknowledged that there's a 4th level of scrutiny. Okay. But so when the district court here is saying that the evidence does not show, this threatened dramatic change, I think what's happening without the court really talking about it is it's placing the burden on the state with respect to the specific interests that they have advanced. So state, if you're going to claim that the law serves this interest, you have to actually bring up evidence, right? But then, when it gets to the catch-all, right, which is the any conceivable legitimate state interest, perhaps that's where the burden shifts back to the government. But there's not any support for that in precedent. And I think it's a powerful, interesting, kind of not entirely upfront move.
By the judge or by, is that what you mean? That his
Sort of.
shifting of the burden isn't an upfront move? Yeah, no, I'm just.
Yeah, I don't mean that.
Not upset with you.
No, it's so deeply ingrained in me, not to cast any aspersions against judges. But, I just think in terms of the reasoning, I just think it's an interesting turning point. The claim that, I meant to do this for you guys too. So, each of these can be evaluated on the 2 prongs of rational basis review. Is it a legitimate state interest? Is the classification rationally related to that? If you want to preserve the definition of marriage as being between a man and a woman, yes, this classification is perfectly tailored to accomplishing that goal. The question there is whether that is a legitimate state interest. The court has elsewhere, I'm trying to remember the case, but described this as a concise expression of the intent to discriminate. So just say, well, we want to keep X, Y, or Z for ourselves, or for this group and not this group. It's tautological, it's circular reasoning, it's nothing more than saying we want to be able to discriminate. And that in and of itself is insufficient. Okay? As is the sort of bare goal of maintaining tradition for its own sake. Yeah.
So RR is rational review?
Rationally related.
Okay.
Yeah. Maybe this is a legitimate state interest, but there's no sense that the law is necessary. Well, the law is advancing this in any way because it doesn't really see that there's a problem. So the abstract is a legitimate state interest, but when the rubber hits the road, there's nothing really for the law to contend with here.
Can I just ask one more question on that point?
You guys can ask as many
the
questions
burden
as you
thing?
want.
So you were saying that even though it's not a true burden shift, the court's basically saying the burden will shift to the state to show that there would be a dramatic change of some sort? Okay. Just want to make sure I understand that.
Because again, under rational, I think the way I understand traditional rational basis review is the court should be saying, yeah, that sounds good. You want caution? That sounds good. And I can see how this law would do that. Case closed. No reference to evidence.
Mm-hmm.
Okay. Which is why rational basis review, this is kind of, so I'm working on this article on suspect classification right now, and sort of, I think I made this point in class before, but the idea that traditional rational basis review is the standard of Plessy versus Ferguson. There's no pushback. There's no pushback against discriminatory laws, essentially, under traditional deferential rational basis review. Okay, so preferring opposite sex parenting. You know, the court sort of implies, well, this would be okay if that were actually better for kids, but the evidence does not show that opposite sex parenting is better for kids. And this law has no effect on parenting. This is the same with Proposition 8 and with DOMA, because this idea of procreation and child rearing is raised in both cases. But on the level of, is the classification rationally related? These, you know, many of these states, but California certainly, you have all sorts of parenting arrangements open to same-sex couples. So even if this were a legitimate state interest, the law is actually not doing anything to advance that interest, is the idea, okay? Treating different things differently. Different names for different things. You know, not a legitimate state interest. And again, I think that relates to the idea of basically expressing a concise intent to discriminate. It's really kind of, it begs the question of justification, right? So, right, I don't know if he's the only one who does this, but so Erwin Chemerinsky talks about, you know, the central question of equal protection law, is the discrimination at issue justified, right? And so, whenever the law treats groups of persons in a way that's different, you have to look to that justification. And saying that your intent is to treat them differently is not really a justification, okay? And I apologize, I actually got these in the wrong order from the district court. Freedom of association. That is not only a legitimate state interest, that is a compelling state interest likely, right? So what's the problem?
No rational relationship?
Why?
Doesn't he say that
What is
it doesn't affect any First Amendment rights?
Right, again, it's sort of saying there's no mechanism in place with this law to actually serve the function of preserving freedom of association. Do you guys buy that argument? What's the best argument that Prop 8 in particular does serve to promote freedom of association? What type of freedom of association does it protect or
Same opposite sex married couples?
Say again? Full sentence?
Well, it doesn't, I mean, freedom of association, isn't that about, I mean, First Amendment, well, what I said was opposite sex, I don't remember, couples.
So, if this is marriage, it's like opposite sex couples are sort of, you know, well, we want to be alone in here. We do not want to associate, freedom not to associate, which is brought up in Rowe as well. But also maybe on a more societal level. You know, the majority of people in society, as demonstrated by enacting this law, don't want to have to accept same-sex couples as being equivalent to opposite-sex couples, or as being entitled to the right to marriage.
But, I mean, isn't freedom of association, I just don't get it.
Is it more of a positive right? Mm-hmm. Right, like, okay, I have the right to...
Well, isn't it
be
free
a
from
part of this group?
governmental, the government stopping you from doing something? So the government isn't stopping anybody by allowing them to get married. You, as an opposite-sex couple, can still get married and associate with only opposite-sex couples that are married as well.
Isn't the government forcing you to endorse the idea of same-sex marriage as legitimate? Isn't that intrusion on the part of the government?
I mean, no, isn't it just government? It's not forcing you to. I just don't get the argument.
Well, I mean, that's the response maybe then. It's not really forcing you to do anything because the key link in that sort of reasoning is that the government's regulation of marriage is an expression of social consensus. And it's not clear that that's true. Right? But I do think this argument has some more legs to it than maybe is acknowledged. Other thoughts about freedom of association? Yeah.
How would you spell out the argument then, that the government is forcing you to acknowledge same-sex couples as having?
I mean, if you think about it, there is some consequence, okay? So,
I mean, but then couldn't you extend that to the race context as far as couldn't their argument in Brown or whatever have been like, we only want to associate with...
that's exactly the argument.
So.
But the question is, then that raises the question of whether race discrimination and sexual orientation discrimination are equally offensive and unfair. A point on which people disagree. You know, and that's what was a major point of Justice Scalia in his dissent in Romer, was that, you know, it's improper to equate the perniciousness of race discrimination with sexual orientation discrimination. I mean, I think the key questions there, to kind of get back to your question, Allison, is there state action here? Yes, there is state action, okay? The majority of people in California said that they did not want recognition of same-sex marriage, and now the judiciary is coming in and saying, well, sorry, you're going to have to accept that, right? And then the question is, well, what's that sort of nexus of meaning? Okay, what is the connection between the state's definition of marriage and the individual's ability to express him or herself and your values, essentially?
Well, and what's the injury?
What is the injury?
I mean,
can anyone come up with an analog that may feel more intuitively injurious to one's freedom of association? How about, I'm not saying this is a freedom of association argument, but how about when the government decides to go into what you consider to be an unjust war? Right? I mean, is there some connection between official actions by the government that don't necessarily, affect you in a direct, concrete way, but your sort of, your ideas, your identity as a citizen?
Wasn't that just a general injury? I mean, right? Like, if you disagree with the wording that the government has gone into, isn't that not a specific, whatever their test is? It's it is individual.
For like a state
your personal,
right? Yeah. So freedom of association injury would have to be something much more concrete, like, well, give me an example.
That you work for a peace organization in Afghanistan. No, I don't know.
Well, what about if you're not allowed to be a member of a particular political group because you're a law clerk? That might be a sort of freedom of association argument. That's got a little more. I mean, in Romer, do you guys remember in Romer how it worked? So basically, Amendment 2 was designed to preserve the right of private parties to discriminate against homosexuals, right? And so there, I think the freedom of association argument had a little more, traction because I don't want to rent this room in my house to a homosexual, right? And by not allowing me to discriminate, you're intruding on my freedom of association, my freedom not to associate with a particular group or what have you. I don't know if this argument wins the day, but I think it deserves a little more exploration than it receives sometimes. Any other thoughts or questions?
Well, for those religious groups, I guess, paying benefits and stuff could be an issue. I guess here it's not, because in California they're paying benefits under domestic partnerships or whatever. Anyway, so there's no change, but for other states, I guess they could have a little better argument that you're forcing us to pay for stuff
To
we
subsidize
disagree
this,
with.
right?
Almost like an abortion religious argument.
And what's the counter argument? Taxpayer standing.
And it's not what he said, that they're under the domestic partnership agreement and marriage, they're getting all the same things.
Well, right, so that goes under rationally related, right? This law is actually not doing anything to preserve your ability not to support that. But also the counter argument is there's no general taxpayer standing if you object to particular laws, whether it's war, abortion, or what have you. The other piece, I think this is part of how the argument about marriage equality has become more sophisticated, is sort of disaggregating the religious, social, and state-regulated aspects of marriage. Because that had really been conflated in a lot of the early arguments. But, here, there's no requirement that a particular church recognize a particular marriage or anything like that.
Oh, I'm thinking more of religious employers paying benefits.
Okay, so
But that's what she said, right? That you just,
well, that's a different situation, right? But I'm not sure. I'm not sure how that plays out.
if that changes under the marriage versus domestic partnership.
Yeah, in California, I don't think there's any
Right.
change.
But then they just
No.
limited it to
So-
California anyway.
Right, but then outside of California.
Right, so let's
like-
imagine a situation where there are no rights for same-sex couples, and all of a sudden they have to be incorporated in that.
Yeah.
I don't know. I don't know how that would play out, or exactly what the arguments would be there.
But is their argument, I see their argument as that box that you drew. I mean, the freedom to association is, we think marriage is this, what's the word? I'm thinking sanctity, yeah. And so the fact that.
Sacrosanct.
Sacrosanct. So the
Yeah.
fact that you're trying to extend it to same-sex couples is encroaching on my
Right.
relationship.
Like cheapens your rights.
Right.
Yes,
Yeah.
exactly, right. And that was kind of, I think that idea has kind of floated around some of the race discrimination issues as well. And what that posits is some kind of, like values universe in which, everyone who's participating in that can kind of have the ability to degrade, the other participants by expressing or somehow institutionalizing values that they disagree with, which is an interesting idea, but I think is not really
Right.
how our society works.
Yeah, that's not a legal argument, just.
Well, and to sort of say, well, yeah, I'm degraded by associating with people that I don't think are equal,
It's not a
it kind of goes to the heart of equal
legitimate
protection.
It's like constitutionally too bad.
I
don't like.
That's great. Okay, good stuff, guys, good stuff. In the any other legitimate state interest category, this is where the court mentions moral disapproval after Lawrence, not okay. Right? And the court actually then looks at, the campaign literature and its, fear, stereotype, etc. Animus, essentially. Animus towards a particular social group. We just don't like you. You make us uncomfortable. We don't think you deserve this. That is also in and of itself insufficient. Okay. And so, I guess one of the persistent questions here is sort of, well, did the district court...
Before you erase that, can we fill in these?
Oh, yeah. So freedom of association, yes, that's extremely important, but this law does nothing to advance that. And there are no, other legitimate state interests that the court could conceive of. It's a little bit bizarre test, though, right? Because you're leaving it up to the court to conceive of these other ideas. Like, I think this is a very problematic aspect of rational basis review. Okay? And this is, it's not the best diagram in the world, but just to recognize that with any equal protection level of scrutiny, you always have those two avenues of argumentation, right? That you're going to have arguments on either side of. The sufficiency of the state interest and the sufficiency of the tailoring. Okay, which again, it's really unclear from precedent what it takes to fail the tailoring prong of rational basis review. Because saying that a category or classification is under-inclusive or over-inclusive should be irrelevant under rational basis review. But the Rowe court, of course, brought up this idea that if it was radically under-inclusive or radically over-inclusive, that was evidence of animus. Kind of weird stuff.
So for 4 and 6, for rationally related, we don't know.
Well, again, I think it's actually, it's similar to 1. If you want to treat same-sex couples differently, you got it. This is perfect. This is the perfect law to do that. But that's not a valid goal, right? And then 6, if you want to express moral disapproval, it's probably a pretty good vehicle for that. but that's not a valid goal. Does that make sense?
Okay.
But yeah, a lot of times the illegitimate state interests, the law will be perfectly tailored for that. Which is kind of evidence the law is doing something it shouldn't be doing. All right. So, Ninth Circuit. Ninth Circuit goes in a really different direction. You guys have your Ninth Circuit decision in front of you. If you look at the first sentence.
I have a procedural question.
Yes. Ooh, my favorite kind of question.
How, I don't really know how to ask this. I mean, they have this new argument, and they said it wasn't brought before. Doesn't...
Which argument?
The argument they based their decision on, that they, took away rights. How did they get that in there if it wasn't a preserved argument or the basis of the decision of the lower court? And they even say that this is the first time that they bring it up.
Can you point to that? I know the passage you're talking about. Can you help me find it?
Yeah.
The exact language in here. I know they're we're going to take this third pass because it's the narrowest, right?
Yeah.
Page 1076.
So they end with the standard of review.
The close courts generally decide constitutional questions on the merits ground and are fully considered.
Yeah, so he says that under 13 and 14, plaintiffs elaborate upon those arguments, the ones that were in the district court, and then he says, also offer a third argument. I guess maybe I just assumed that it was new.
I don't know that it's new. And so a couple of things about that. First of all, they're affirming. So if they properly reach, so again, if you say, well, rational basis review applies, there's really no controversy there. You're avoiding a whole bunch of controversy, right? Because that's what proponents of Proposition 8 want. They want rational basis review to apply. And then the court has to ask itself, and there's all this room for speculation, right? Given that it could be any conceivable state interest. So it's kind of unbound by some of the rules of issue preservation and argument preservation. But the court can latch onto any feasible argument that the law fails rational basis review that is supported by the record and by the precedent.
Okay, so even though I guess the
And I
district
think
court
the parties
didn't
argued it
have
too.
to, okay, so the district court didn't have to address this argument that they eventually decide on because he said it failed these other ones, so it wouldn't matter anyways. And then they decided to go on that one even though he didn't discuss it. Okay.
And I actually think here, this is about the framing of the issue.
Yeah.
It's not actually about the substantive decision because the district court said, basically, address the idea of animus towards homosexuals as being insufficient. But what the Ninth Circuit did that is really interesting, okay, so rational basis review. So does a law survive rational basis review? Rule survives rational basis review if the law serves a legitimate state interest. The classification is rationally related. And I don't even know how to kind of fit this in there. But what the court said, maybe this is how it works, and looking at whether there was a legitimate state interest was, there has to be a legitimate state interest for taking rights away. Not just for enacting the law, but and I don't think that's really supported by precedent. Romer doesn't really say it exactly like that, that there's a different sort of rational basis review inquiry when a law takes rights away. And what is very interesting, the sort of category of unintended consequences is in the Jackson decision. I think I mentioned this to you guys. Federal District Court for Hawaii. I don't know what the abbreviation is. Sorry. The court followed Judge Reinhardt's lead and said, well, we don't look at, the justification for the law itself, but we really focus on the change in the law. And in Hawaii, because there had been no prior grant of marriage rights to same-sex couples, the law stood. And that really seems wrong to me, but that's the path that Judge Reinhardt laid forth.
And he probably didn't mean to do that. Like, the Jackson came out and he was like, oh crap.
I'm really curious. I'm really curious.
I mean, what other states actually had gay rights in place for
None.
marriage? I mean, California was the only one that was done by a court decision, right?
Yeah. As far as I know, and I've I've kind of reviewed the law in the different jurisdictions, a fair amount. There's no other jurisdiction that granted full marriage rights and then took them away. So Judge Reinhardt's reasoning doesn't apply anywhere else in the country.
What good is it going to do them if there's a Supreme Court decision granting gay marriages, but only for the state of California?
Well, I think, it's kind of, one of my preoccupations with this decision is that it really, in a sense, hung marriage equality in other jurisdictions out to dry. Because there's no one else that's going to fit this pattern. Mm-hmm. And very easy. So you guys, know about analogizing and distinguishing. Well, now this is the ultimately distinguishable case. It was done by the Jackson Court, can be done by the Supreme Court, and then can be done by litigators in other jurisdictions, which I suspect was not, the sort of ultimate goal of Judge Reinhardt. And the thing is, so if a court decides an issue, okay, so, this is sort of the point of more forgetting Romer, and the court says, well, this is animus, right? It doesn't mean there's not a whole other sort of range of fact patterns of laws that could be animus. But that's kind of, was Judge Reinhardt saying, this is sufficient but not necessary? Right? So the state takes away rights, well, that's always animus, but there could also be other types of animus. Or is the lesson of Judge Reinhardt's opinion, this is the only case where you can find animus? And again, I think the limited precedent that there is on the issue of unconstitutional animus makes it clear that you do not have to take away rights, pre-existing rights, for animus to be present. And again, the clearest case on that is Claiborne, right? Where you had a group of folks with cognitive disabilities making an application for group housing. Wasn't something they'd had before. City council says no because other neighbors are afraid of you. That's animus. That's not permissible basis for public law for state action. And that, falls outside of the category that Judge Reinhardt defined. But I think he should have been a lot clearer on that point. So, kind of getting back to your point, Alexis, I think this is really about the framing of the issue, right? And saying, well, it's not just, you don't just have to justify the law on its face, you have to justify the change that the law enacted, which is really not, something we've seen before. And this is, what I really think is interesting about this decision is this language of constraint, right? I mean, federal judges, pretty powerful, right? But there are all these sort of constraints on the Ninth Circuit, right? So they're constrained to frame the issue as narrowly as possible. They're constrained by what the California Supreme Court decided vis-a-vis what? Standing, yeah, that was a matter of state law. And you guys saw how that kind of played out.
Certified question about...
That was, oh yeah, go ahead. No, it wasn't a so the standing issue was a certified question.
Okay.
The other issue was not.
Okay.
The other issue just came up in the prior state court litigation.
But they, is it that the federal courts have to defer to them on the factual findings of how it will how the law will affect things on the ground.
It's an interpretation of state law.
Okay.
Okay, so the federal court has to defer on that point. So the Ninth Circuit is constrained by those state court interpretations. It's constrained by precedent.
But that was the point of state law, what Allison was saying, right? The
scope.
legal effect
Yeah.
of property.
Yeah, yep. So yeah, the two state law issues here. And I think this is really interesting way that state courts can influence federal civil rights litigation. I mean, not, purposefully, but one, on the standing issue, right, what's the theme of the whole discussion of the standing issue? Federalism, right? States can decide who represents them in defending a particular law.
I think they kind of even seem to disagree, because they were saying like it's not no matter if the federal court disagrees or not, or that whether it considers that it unwise for a state court or a state to authorize these people to.
I think it's a real legitimacy problem. If you have a federal court striking down a state law and you say that no one can step up and defend the law, I think, but yeah. And then the scope and impact of Prop 8. This is incredibly important to the reasoning in this case. Proposition 8 does one thing and one thing only. It deprives same-sex couples of this right. Does not affect child rearing, does not affect society at large, etc. Okay.
That whole issue kind of bothered me too, because it was almost like you're leaving the door open to where if you have a more draconian law, then is it okay? Like, if you say, well, you can't get married and you can't stop children because of this and you can't do all these other things, and it has more effect, then I don't know, it just seemed to open some strange doors.
Yeah, I think that's right. Again, I don't know if the Jackson court seized on particularly that formulation of the issue, but sort of the idea that, again, if there hadn't been marriage rights previously, then you couldn't claim that the exact scope and impact was to, remove the set of rights, right? It's more, and this is my other piece that I'm writing. I'm trying to get way too much done right now, but sort of looking at the reasoning from the Ninth Circuit and how would that play out in different jurisdictions where there's different procedural posture behind the law, right? So places where Judge Reinhart's reasoning might not apply. Everywhere, because there was no prior marriage right. Anywhere, so the idea is, well, we're just, let me explain. So anyway, there's no prior marriage right. You have places where this is sort of just a traditional definition of marriage that's been around for a while. It wasn't kind of recently enacted purposely to stem the tide of same-sex marriage recognition. And then you have places where all you have is this heterosexual marriage definition. And then you have places where you have a heterosexual marriage definition plus mini-domas, which are basically, not only are we saying marriage is a purely heterosexual institution, but we're affirmatively refusing to acknowledge same-sex marriage from other states. You have places with limited civil union rights. You have places with full civil union rights. But let's say you have a place with full civil union rights that never gave marriage and took it away, right? Is there animus there? Right? The court makes a lot, and so Kenji Yoshina had this piece on SCOTUS blog, actually, if you guys want to find it there, about the different paths the Supreme Court could take. And one of the ones he pointed out would be a very narrow kind of affirmance where, it's only impermissible to exclude same-sex couples from marriage where you've given them all the other incidents of marriage. So, and this kind of goes to your, this sort of perverse reasoning, right? So, if you have treated same-sex couples as equal for all intents and purposes, then you can't just take away the symbolic benefit of the term marriage. But if you treated them as unequal, as not entitled to all the incidents of marriage, then you're doing something more than just a symbolic thumbing of the nose by excluding that group from marriage, right?
But then doesn't that create the I don't know, what it would be called, maybe a dormant commerce clause problem, of that you can go different places and be treated differently by different states?
Full faith and credit problem.
Oh, yeah.
Yeah.
I don't know what it was.
So, yes, and that would be a type of claim that could be brought. Right now, what does DOMA do? Section 2 says to states, you don't have to recognize out-of-state same-sex marriages. Section 3 says, and for federal purposes, marriage is man plus woman. Okay, so this is
that violative of the full faith and credit clause, though?
not being a full faith and credit clause scholar by any stretch of the imagination. I'm guessing that there is some latitude for Congress to say, these are the types of things that fall outside of the scope of that. But I don't really know. I mean, what it is basically saying is full faith and credit principles do not apply to recognition of same-sex marriage.
Well, it's a state law, so I don't see why they would need to expand it outside their jurisdiction anyways.
On Prop 8?
Yeah.
Yeah, no, so Prop 8,
I mean, they can't force it.
there's no, the mini domas are what are subject to a full faith and credit clause type of argument. But the simple definition of marriage as being heterosexual is not. Right? Because you could have a state that defines marriage as traditional man-woman marriage, but would still recognize same-sex marriages that have been validated in other jurisdictions. There's a lot of combinations that are possible. Okay?
That to me is what the full faith and credit clause would require. That regardless of what your state's laws are, you have to give a certain amount of what's the word? Not deference, but
Comedy?
yeah, to other states' laws. Like I'm thinking if someone has
But it can't be a universal, right? It can't be an absolute principle.
right. Yeah, I guess so.
I mean, again, I don't know the dynamics of it. I don't know a lot about that area of law, but that would be my supposition is that, there's some, I can't think of another example right now, but like with adoption and child support orders and things like that, I mean, it's not always boom, it's a law from another state, therefore you have to enforce it in your state.
I was thinking about community property states versus non-community property states.
Yeah. So full faith and credit clause is sort of an idea that's out there, but certainly not absolute with respect to every issue. That much I can say with quasi-authority. Okay. So, you guys have kind of gotten to the heart of the decision here and sort of what, the narrow grounds upon which it rests, right? What I would say is significant about the Ninth Circuit decision, first of all, I really feel like Judge Walker must have wept. I mean, just disregarded the vast majority of his careful factual findings, right? And to what end? To eliminate any controversy about whether those were adjudicative or legislative facts. Only facts the court relied on were the facts around the campaign literature surrounding Proposition 8. So the court sort of first limits the factual universe, deals with the standard of review issue, has this choice of how to frame the issue, right? As a due process question, a sort of general equal protection question, or this narrow, question of what's the justification for taking away rights, suggesting that there has to be maybe a more weighty justification for taking away rights, but again, the court's only applying rational basis review. And so, the issue, is there a rational basis for taking away previously granted rights? And then the court goes into the description of what Prop 8 did and didn't do. And that, of course, coming from the California Supreme Court. And then the court goes and talks about Romer for quite a while, right? Romer is, it's like I said, a sort of fixation with Romer. What rule does the Ninth Circuit extract from Romer?
That there has to be a rational basis for the taking away of the right.
Okay. And what does that mean? What is rational, what is not? What is legitimate state interest, what is not in that context?
If the only state interest is to take away rights just for the sake of taking away rights, then it's not legitimate.
Okay. So, I want to come back to what you just said here. So if you remember Romer, or thinking about the way the Ninth Circuit recapitulated it, say that again?
That state interest is not legitimate if the only reason is to, just for the sake of taking away rights.
Okay. Is that all of it?
No, because there's other, you could come up with other state interests. That's when the rational basis of the fight comes in.
Romer does some really weird stuff. If you've read my little essay, you understand my particular view on it. To take away rights from whom?
A politically less powerful.
Well,
politically powerless.
No, see, that's interesting because you're importing the suspect classification language, and that's not actually what it says. Am I remember?
Minority.
Unpopular.
And how does that idea relate to suspect classification analysis? It's like the court is kind of sort of saying that sexual orientation is a suspect classification, but it's not going through the whole, 5-factor test, right? What counts as evidence of animus according to the Romer court, or according to?
Not having a good reason.
Yeah. Right? So, another way of thinking about this issue, and I apologize that my handwriting is so awful, legitimate state interest, rule, animus, is not a legitimate state interest. Issue, is there animus, rule, Bill, animus where?
Animus where there is no legitimate state interest.
Right? Or where there's no rational relationship. I mean, that's a problem. That's a problematic, circular reasoning. And it's also, it makes the finding of the presence of animus entirely gratuitous. If there's no legitimate state interest served by the law, it fails rational basis review, period. You don't then have to impute the motives of the people who passed the law, which is kind of what Justice Scalia says. Okay? So, then when the Ninth Circuit applies Romer's reasoning to Proposition 8, it says, okay, the child-rearing responsible procreation argument doesn't fly, it's not a rational basis. Caution argument, not a rational basis. Religious freedom argument, not a rational basis. And preventing same-sex education or education about same-sex couples in schools, not a rational basis. Is there anything else, Judge Reinhardt? Wow, without any rational bases, all I can conclude is that this is based on animus, and that is supported by the sort of hateful campaign literature. Very confusing, in terms of what is the rule of law for animus coming out of that case, coming out of Romer. How will the Supreme Court look upon this? I think, well, I don't know. I actually have no idea. So I think, again, the main thing about the Ninth Circuit decision is how radically it kind of pursued its own agenda and didn't really, in a lot of ways, capitalize on some of the strengths of the district court decision.
Why do you think Reinhardt did that?
He's a megalomaniac? I don't know.
What did you say?
I think it was very strategic, just the same way that the district court's decision was very strategic from a district court perspective. I'm going to make this all about findings of fact. And the Ninth Circuit decision was very strategic from an appellate court perspective. How so? I think we talked about this at the beginning of class, or the beginning of the semester. Who wrote Romer?
Kennedy.
Yeah.
Yeah.
Who was still in the court as a swing vote? Yeah. So, that certainly is one theory behind it. I mean, obviously you want to ground your argument in precedent. But, I think this is some of the worst precedent one could possibly rely on, just because of the, we talked a little bit about the historically compromised position of Romer. So decided, Bauer versus Harvard was still good law. So it really is a decision that doesn't make any sense. Because Bauer said that you could criminalize homosexual sodomy and you could criminalize, in a sense, homosexual identity. So the Romer and Bauer still fit very nicely together.
So with it going this direction, do you think kind of the whole idea of animus will sort of be destroyed or made meaningless? That it's, if it becomes sort of this gratuitous thing that you find when there's no rational basis.
I would hope that the court would not go in that direction, because it really would eviscerate, that body, as small as it is, it would eviscerate that body of law, that whole sort of concept. But the case law on animus really doesn't make any sense right now. So, for the purposes of my scholarship, I would really love it if the court, took the opportunity to rationalize this doctrine and really give it some meaning. But I don't know whether the court will do. With DOMA, I think with DOMA it's so easy to argue there's actually just not a rational basis. With the state law, because DOMA is the federal government interfering with marriage, it just doesn't make sense, right? But with the state law provisions, it's much more a reflection of democratic processes. My kind of point in the pieces that I wrote is that there's one case where it's easy to say that we have animus, and that's where you have a legislative history. It's like, we hate these people, and we morally disapprove of them. And you have that with both DOMA and Prop 8. In DOMA, it's the bare purpose of the enactment is to express moral disapproval of homosexuality, which was okay in 1996, but not post-Lawrence. And with Prop 8, there's all this campaign literature. But Romer talks not at all about the sort of spiteful campaign literature in that case, because it really couldn't make it about disapproving of homosexuality because of ours. So Romer doesn't point out the easy path